Welcome to Internet Inqalab. We have a series of debates where we're going to be discussing the Information Technology Act and the amendments that were put in afterwards. The Information Act amendments were discussed in 2008 in Parliament and then passed in 2009. I have with us Akhil Sibal, who is a High Court and Supreme Court lawyer, Misha Chowdhury, who is a practicing lawyer both in New York and in India. She's also the executive director of a non-profit organization called Software Freedom Law Center, and we have Kanchan Gupta, who is the editor of Niti Central. Can we start with you, Mishi? If you can explain to us historically how the Information Act was passed, what it meant when it was discussed in Parliament, and finally when the amendments were passed, what does it mean to us as lay people?
The Information Technology Act was passed in 2000. However, the amendments which perhaps we are referring to right now, Section 66A and Section 79, came into effect in 2009 by an Act 10. It's important to see why these two amendments are particularly crucial out here. In 2004, there was a case of Bazi.com in which Avnish Bajaj, this Bazi.com is an auction portal, a website, which is somewhat like eBay.
And he was arrested for
he was the CEO.
Activity on his...
Some DVD which had some objectionable material of two high school students was being peddled by someone else, a third party, an engineering student, and the CEO of the website was arrested. That time he went through some legal trouble, of course, and the industry gave a call that if these platforms, these intermediaries who are just using the internet to either reach out or provide valuable services, if they are not protected, if there is no safe harbor given to someone who is just either the messenger or only a provider of a service, somewhat like an Airtel or an MTNL who just give you a connection to the net, or somebody like Google or Facebook who are giving you platforms to talk, or an auction website, if these are not given any kind of a protection, then there would be problem for e-commerce, because it's difficult to run a business if all your money is going to be paid to lawyers. So the industry gave a call and an amendment was made, which is Section 79, where intermediaries, as the official term goes, these are called intermediaries, they were given safe harbor protection. But there was only some conditions out there. They said if the content is user-generated, not generated by the intermediary themselves, and if they follow certain due diligence for the activities under the Act, then they will have a safe harbor protection. So if they're sued in the court of law, then they can come and say, I did not do it, it's not my fault, someone posted this on my website.
But it didn't exactly turn out that way.
It didn't turn out that way. That was the intention, to encourage e-commerce, and the Act itself was supposed to encourage e-commerce. But then in April of 2011, Department of Information Technology of the government came up with rules under Section 79, because there are certain guidelines which can be prescribed by the executive. They came up with rules where the effect has been that there has been a rollback of these protection which were intended for these
So now
platforms.
It makes websites more responsible
Yes.
for anything that is posted. Akhil, do you agree with this, her interpretation of the law?
I think, we have to ask ourselves a fundamental question, which is the speech freedom on the internet any different? Should it be any different than the freedom of speech and everything that goes along with it, that is enjoyed in other forms of communication?
Is it different?
Well, there is a difference, and that difference, in fact, tilts, to my mind, the other way in favor of greater safeguards. And the reason is this, and the line is drawn at a slightly different point. And it's for this reason. The internet permits something which otherwise is not as available, which is anonymity of speech. And it's a unique avenue in that sense, different from other mediums on which you can broadcast your speech or convey your speech.
But the reality is, Akhil, the average person cannot broadcast their speech. They cannot respond to a newspaper article or a television program the way they can on the net. For example, News Laundry, we get enough criticism and brickbats and even abuse, which we handle and accept.
I agree with that.
Right?
And in fact, therefore, your point is, with which I agree, that this anonymity and this medium provides a freedom that is unprecedented, and in fact it's a fillip in favor of free speech, and it promotes speech and free speech in a way that no other medium does, because in fact people would be, one would imagine, would be freer in speaking their mind if their identity is not disclosed in certain scenarios. And so in that sense it encourages free speech and boosts it, which is a good thing. At the same time, and with this encouragement also comes the danger that with the anonymity you have reckless speech for which it's very difficult to hold anybody accountable. And so therefore you have irresponsible speech of a kind which our law otherwise recognizes to fall foul of that Lakshman Rekha. Now, there may be an argument out there that, look, that Lakshman Rekha shouldn't be there at all. There's something wrong with our constitution when it says that you can restrict it on grounds of morality, decency, defamation, public order, and so on. But that's a whole different argument. If we are to operate within the construct that exists, our constitution and the laws that are already there, then you're facing a unique problem where, along with this amazing freedom, comes often the danger of lack of accountability.
But if we're functioning under the same construction, we really don't need a Section 66 or 79. Kanchan, I'm sure you disagree.
Yeah. There are 3 points which I think merit mention over here. The internet doesn't only allow you access to what people living in India are saying or putting up on the net. It allows you access to what people globally are putting up on the net. So you could silence me over here through 66A or any other section of the IT Act which is applicable. But beyond that, what do you achieve? So I get penalized.
And to put in for our viewers, you did get penalized.
Yeah, I was penalized.
During
exactly a year ago.
In fact, this month, it was amazing. It's exactly a year ago this month when you were here and we were discussing the fact that your Twitter handle was blocked and you were called in and you had to be interrogated by a desk of people with bureaucrats who questioned you on an image that you had put.
It was very reminiscent of the Soviet era. I mean, it was a dark room with very grim-looking officials sitting over there, and
the only thing missing was the vodka.
The only thing missing was the vodka. There was a single light, and my crime was that I had, and I haven't shared this with anybody. This is the first time, but I think they did tell me that I should not talk about it. So I promised I wouldn't talk about it, but I think we should talk about it. That I had, through my Twitter handle, I had circulated a cartoon. The cartoon showed a Taliban scolding a woman for not putting her toddler, a girl, in a burqa because the child was giving him dirty ideas. So it was a 4-box cartoon. The first was the scolding. Second is that this woman puts a little hijab around the child, and the Talib is still not happy with it. And finally, the child is also in a burqa. So they found it objectionable. Now, I didn't want to argue with them because they were carrying out a political agenda. That was just an excuse. My Twitter handle was blocked because of my political views. And even friends in the government agreed that that was the reason.
Now, talking about what Akhil said, coming back to that a bit.
No, so that brings me to the second point.
Yes, because he says these safeguards are important.
No, I agree with him. Safeguards are important. I mean, you could have a lunatic who tries to put up a child for sale on a Bazi.com or any other site. I mean, just for the lark of it maybe, or just because it gives him or her a kick. So those things need to be stopped. And to an extent, yes, those who own and operate such platforms, yes, they are also responsible. There are enough tools now to prevent postings of this kind.
Could those tools be used without Section 66A and
Yeah.
79?
Those,
so we really did not need Section 66A.
Yeah, I now have switched over entirely to digital media, and there is software which automatically prevents the posting of anything which has say an F word in it or things like that. You could do it. So there is a responsibility which devolves on the person who's running that site, yes. Where it becomes tricky, and that is the third point. You see, our constitution, when it was framed, allowed for absolute freedom of speech.
Not exactly.
Yes,
with 99A, with that, we have a
First
problem there.
He's right
I'm
about
right.
First Amendment.
But then Nehru chickened out.
When we adopted a constitution,
Initially.
yes, there was absolute freedom of speech. Then we had our First Amendment, which was curtailing the freedom of speech.
Right.
And that curtailment, that amendment came when criticism of the government, of free India began.
Exactly.
Yes.
Because till then, criticism of government was very nice and even acceptable to Mr. Nehru, because we were criticizing
The British.
a colonial government. But when it came, when the criticism was directed at him and his government, it was no longer acceptable.
Couldn't handle it.
The irony of it all is that we say we are the world's largest democracy and America is the other largest democracy. The First Amendment in America was to institute absolute freedom of speech.
Yes.
Inviolable, can't be taken away from you, cannot be curtailed under any circumstances. And here we acted the other way around.
Mishi, you wanted to disagree
yes,
with...
I want to disagree because I agree with Kanchan about how 19 clause 2, which is saying when we take our
But let's go back to what you were disagreeing with Akhil.
Akhil, I will say why on 3 points. I will come to anonymity later. The first thing is, it's all right. Even if I were to agree that whatever is in the Constitution, the reasonable restriction on speech which is not online. In India, there are restrictions on our speech. We cannot have absolute freedom of speech. There can be restrictions imposed in favor of national integrity, security, defamation, public order, and morality. Even if we just accept that, although now, because of the internet, this is a time when we should be rethinking of those restrictions also. But even if we were to just stick to what the Constitution says today, Section 66A and the rules under 79 go beyond those restrictions. So online, you have a much more limited free speech than you have offline in India. It's actually, that is why these rules
Is it because of the words that are added, such as inconvenience?
Yes, that is under Section 66A.
Embarrassment.
They say, I would read it out to you. Any person who sends by means of a computer resource, I will read Section 6, any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience. Now, if purpose of causing annoyance or inconvenience had been accepted by the Constitution as a reasonable restriction, I would not object it on these grounds. Right now, offline speech is much wider. I can only be restricted for the reasons which fall under the Constitution. But online speech, if you are talking on internet, it is subject to way more restrictions. That's why the rules are unconstitutional, and 66A is as well.
Let me respond to a lot of these issues. One is that I am yet to come across a jurisdiction that has absolute freedom of speech. Even the US.
Jurisdiction in the world, you're saying?
In the world. Any jurisdiction which has absolute freedom of speech, none of them do. Even in the US, for example, you have defamation laws.
Yes. You see, when I used the expression absolute freedom of speech,
yes.
I did not mean that I have the right to slander you, to abuse you.
So it's not absolute then?
No, when we say absolute freedom of speech, it means I have the right to say something which you may find offensive,
Yes.
which you may find irritating, which
Inconvenient.
Inconvenient and
yes.
embarrassing.
Or you get
But
annoyed
tough
by
luck,
it.
you have to live with it.
And that's the law in India as well.
No, that
No,
is
no, no.
not.
Law in India is
Let
not
me-
that.
let
That
me
is
just
not.
finish.
I have
How
been
is
in
it
this
the law when
business.
she just read the law and says the
I have been
opposite?
in media for 32 years
Yes,
now,
yes.
and every day, I mean, I have to deal with.
Absolutely.
Should I let this go? Shouldn't I let it?
So let's draw a distinction between the law as it is and the law as it is wrongly implemented.
No, Akhil, can I
Where-
ask you one
yes.
which you can answer together?
Yes, sure.
The section 66A, which Mishi read out,
Yes.
is clearly taking the amendment of Article 19 to a longer stretch.
Yes.
Far more than even Jawaharlal Nehru intended.
Okay.
Because that includes inflammatory, far more serious things, defamatory, all that kind of
Yes.
thing. But this is taking it to something very gentle,
Yes.
which is inconvenience, which is every moment in our lives in India.
Sure.
And what is the other one? Inconvenience and
Annoyance.
Annoyance,
Right.
which is every minute of it.
Sure, sure.
So that means it's stretching it to unreasonable. Now you're leaving it to because it's so vague, you're leaving it to the discretion of the people who are going to implement it, which is putting...
A sub-inspector.
Which is, well, they've even raised that now.
Yes.
But even by raising it makes no difference, because if a politician, even a local politician, will tell a sub-inspector to go and arrest 2 people or 1 person, which has happened, as we know the list of people who were arrested, those 2 girls in Mumbai, this Ravi Krishnan who tweeted something about Chidambaram's son. There's this Dalit leader who's been most recently arrested. So there's a host of people who've been arrested for cartoons, Asim Trivedi, all these guys, on the discretion by using this law, not misusing this law, by using this law.
Absolutely.
And then to say that they can be out by with bail, although this law puts them in a position that is far worse than any criminal offense. All right? A criminal offense, you pay 200 rupees, you get away. This, you're in until somebody comes and gets you out.
Yeah, okay.
All right? So this is far more serious than even a murder charge.
What's great about your discussions, unlike the discussions that are out there, is that we get a chance to respond substantially and substantively.
Okay, you'll get your chance.
That's
All
what I'm
right.
going to try to do now,
All
because
right.
that's a
Go
lot to
ahead.
respond to.
Go ahead.
So what I was saying is, firstly, there's no, and I accept the clarification, but therefore there is no such thing in any jurisdiction as absolute freedom of speech, in the sense that without restriction, unfettered in every way possible. So there are restrictions. Those restrictions are recognized the world over. Now, before I come to 66A, leaving that aside for a minute, and I'll deal with it certainly, the law up until, let's put it that way, 66A is quite clear. I mean, there are a plethora of judgments of the Supreme Court that have interpreted the law in the context of say, obscenity. The same issue, the same problem arose with people, hauling others up for obscenity, where they were merely, say, offended. And the Supreme Court says nothing doing. Obscenity, what's meant by obscenity is something at the very extreme end of the spectrum. It's not mere offense. Even if something titillates, it's not obscene in that sense of pornography or anything like that. So obscenity, though the word is obscenity, really what is meant by it is pornography. And that's how it's been interpreted, and there are any number of judgments. Movies that have sought to be banned on the ground that they are offensive or may provoke. Supreme Court has set aside those bans and so on. There are a number of instances. So there is no lack of clarity in that sense. The problem is, and that's a very real problem, and which perhaps ought to have been considered when this law was being framed, and that's a uniquely Indian problem, which is that we tend to borrow our law from
Now,
other
this is the
jurisdictions.
problem. They've even taken from the Telegraph Act of 1935.
Right.
Give me a break.
So you
can't write your laws for today, an Information Technology Act for today, when you're cutting and pasting from a Telegraph Act of 1935,
to some
where
extent,
a colonial power is putting these rules in to stop.
Madhu is making an important point.
Right.
You see, when you keep on constantly borrowing from colonial laws,
Yes.
it shows that you are still mentally stuck in a particular time-space situation.
Yes.
And you refuse to come out of it. Now, you mentioned obscenity.
Yes.
And you did mention about the Supreme Court. I will give you two examples. Lady Chatterley's lover was actually proscribed by the Supreme Court on grounds of obscenity. In the 1980s, mid 1980s, the same Supreme Court lifted the ban or proscription on a Bengali novel written by Somaresh Bosu, saying that times change, situations change. What may have been considered obscene 20 years, 30 years, 50 years ago cannot be considered obscene today.
Yes.
Now, between mid-1980s and 2013, surely we have traveled a longer distance.
Yes.
We even have homosexuality
your law, which criminalized homosexuality or same-sex relationship, has been virtually struck down. It remains on the statute books,
yes,
but it has been read down.
Yes.
Yet, technically, if I were to use any platform on the internet to talk about homosexuality or to put up homosexual literature, I could be penalized under this law. So you are unable to square up. You know, there is a distance that separates government's perception and the reality. Yes, when it comes to child pornography, nobody allows it. No country in the world allows it. Nobody is, and it really is a waste of time starting talking about it, because that's a given. But if we are a matured democracy, if we are a truly matured society, we have to learn to live with inconvenience of thought, inconvenience of opinion, inconvenience of views.
Yeah.
If I find it slanderous, if I find that somebody is defaming me or slandering me, laws exist which both of you are aware of. I can approach the courts of law as an individual to seek redress. The state must stay out. The state has absolutely no business to take down or to demand that Facebook take down pages which have cartoons of Rahul Gandhi or Sonia Gandhi or Narendra Modi or anybody else for that matter. Yeah. How is the state offended?
You know, the thing is, the problem is, my concern with all of these debates, including the discussion we're having right now, is that I feel that the axis of the discussion is wrong. You are identifying a problem, and what you do is you identify a problem, and all of us agree that, for instance, take what happened to you is ridiculous. I mean, that sounds like an absurdity.
Akhil, you make the axis.
That's what I'm trying to do.
Do it.
That's right. So now what you do is, from that problem, you then say, well, let me go to the statute book and find the problem there, whereas the problem isn't there at all. What you illustrated about obscenity is very telling. That's a good example. When you put something in the statute book, where you try to use a word that can allow for some flexibility and evolution over time. The more you narrow the language, the more it becomes specific to that moment in time, and it doesn't remain as a document that can be interpreted over time in different ways.
But flexibility for the authorities who'd use it, not flexibility for the internet user, which is more dangerous.
The narrower you make it, the more you leave out, and the less flexible you make it, and therefore around the world, it's not as if India has come up with this, kind of language all on its own for the first time.
It's copy and pasted from a lot of.
They have accepted. It has been copied from the UK. 4 words out of it. I want to say.
No, but just one thing. I just want to finish the point.